Before I give the word to Dr. Muruka, I will hand over to my colleague Mary, who will take us through part of the day, a bigger part of the day. She'll be the one controlling the proceedings. So, Mary, please, it's your show.
Thank you so much for the introduction. And we're happy and grateful for everyone who's able to join us today. And kindly, Mr. Okot, mute your mic, please. Thank you. Thank you. And we'd like to take it directly to Dr. Andrew, who is the director of DOSH, and we're grateful and privileged to have him here today. And he'll be talking about the trends, the regulation development in the OSH department in Kenya. And we're excited to hear what he will be sharing with us today. Thank you and welcome, Dr. Andrew.
Yes, I think you can hear me.
Good morning, Dr. Muruka.
Can you hear me, Abdul?
Yes, very well, loud and clear. Thank you, sir.
Thanks a lot. Let me share my screen first. I'm able to share.
There you go.
Right, so I was saying I feel greatly honored to be part of this annual conference once more, and I am glad to join other colleagues from different parts of the world so that we are able to share some experiences that we have had with occupational safety and health regulation development.
You're breaking up, Dr.
Country.
Muruka.
Next. Are you able to? Yes, go to the next slide, please. So the agenda that we have, first of all, we'll look at what is to regulate, what is regulation, and then we're going to look at some OSH regulations that we have had in Kenya and how we have gone about the development process of that particular OSH regulation. We'll just look at one example. So the objective really for this session is to appraise participants on occupational safety and health regulation development in Kenya and to share an experience of OSH regulation development. So this is the long process of developing a law. And when I talk about a law here, I mean an act of parliament. So basically, it starts from a bill, and a bill is either introduced at the National Assembly or is introduced at the Senate of the Republic of Kenya. Both are called parliament. And then it goes until the presidential assent when we have a law. And in those acts of parliament, we have provisions for rule making or regulation making. So it's out of this that we get the sources of the power or authority to make regulations. Next. So according to Oxford English Dictionary, regulation is defined as the action or fact of regulating. And to regulate is actually to control or govern or direct. So if you look at the word control, it implies something to do with restrictions. Although in this particular presentation, restriction control would mean what the regulatory agency would require to control as provided for in the regulations. And again, under this presentation, regulations and rules mean the same thing. Next. So in some jurisdictions outside of Kenya, for example, no restrictions, but enables, facilitates, or adjusts activities. So in a regulation making process in Kenya, it could provide for what must be done or how something should be done, given the sources of power under an act of parliament. So the examples of regulations that can be made is how roads will be supplied, for example, health and emergency services, who provide them and how they will be provided for, public education and how public libraries will be managed, for example, and if there are any welfare benefits, reliefs to control, victims of natural disasters, and even bailouts to failed institutions. In occupational safety and health in our country, we have first aid, how first aid should be administered, who should administer first aid, for example, what qualifications would be required, and who should provide for that particular training. So that is with respect to occupational safety and health. So we find that when such services, for example, are regulated, they tend to influence or adjust the conduct of individuals and even companies. So in the abstract, for example, now we can say that all government actions supposedly influence the conduct of individuals and firms. Sometimes these are direct. In most of the cases, sometimes it is not direct. So lawyers have defined regulations as rules of administrative agencies. Now, if you recall from the Directorate of Occupational Safety and Health, this is actually a government department in the State Department for Labor, Ministry of Labor and Social Protection. So it is one of the recognized competent agencies that is supposed to regulate occupational safety and health services in the country. So before a regulation is actually made, there must be authority to make those regulations or those rules. Next. Now, when we look at the Directorate of Occupational Safety and Health, we have two authorities. The first authority is the Occupational Safety and Health Act of 2007. The second authority is actually Work Injury Benefits Act of 2007. So these two pieces of legislation or acts of parliament give the Cabinet Secretary for Labor powers to make certain rules. And we're going to look at the kind of powers that are given under these specific sources of authority. Next. So under the Occupational Safety and Health Act, I have tried to identify a few of the authorities where the minister has been, or the cabinet secretary has been given the power to make rules. So the first one is under section 24.4, then the other one is under section 49.2, where the minister is allowed or authorized to prescribe a standard for adequate ventilation for workplaces. And under section 103, subsection 3, the minister may make rules on medical examinations. And under 126.5, the minister is authorized by law to make rules governing the efficient management and administration of the Occupational Safety and Health Fund. So this is just some of the examples under the Occupational Safety and Health Act, where the minister is empowered by law to make regulations. Under the Work Injury Benefits Act, the Cabinet Secretary for Labor is authorized by law to fix minimum and maximum compensation amounts from time to time, of course, after consultation with the National Council for Occupational Safety and Health in the country. Yeah, so I want us to go direct to one of the examples of a process that has taken us quite some time, and that is the making of the Occupational Safety and Health Oil and Gas Regulations 2020. So these regulations were published recently for public participation. and they were published pursuant to powers conferred by Section 127 of the Occupational Safety and Health Act, number 15 of 2007. So now we look at the journey that we went through to be able to reach where we are with the Occupational Safety and Health Oil and Gas Regulations of 2020. First, it was the duty of the technical department responsible to nominate technical officers from the Directorate of Occupational Safety and Health Services. That was the first step. The second step was the approval by the Secretary of Occupational Safety and Health. The third step was the appointment of Technical Advisory Committee. And the Technical Advisory Committee was tasked with drafting the Occupational Safety and Health Oil and Gas Regulations 2020. And the first task was actually to come up with a zero draft, what we call a zero draft, or the very, very first draft law or regulation that is supposed to be shared by other responsible agencies. Now, the Occupational Safety and Health Oil and Gas Regulations 2020 were developed through the assistance of a consultant, and that consultant was actually hired by the Ministry of Petroleum, and he was given the task to assist the Directorate of Occupational Safety and Health to draft and to come up with OSH oil and gas regulations. So this zero draft was actually submitted to the consultant, and the next step that the consultant did was to conduct a research, and he did a research on how oil and gas regulations look like across the country, both in Asia, in Canada, USA, in UK, in Europe, and also in Norway. In Norway, they consulted heavily the Petroleum Safety Authority of Norway and other countries like South Africa. So all these, including Zimbabwe, all this research was put together, and it led to the development of a working draft. That is improving the draft that they received from the Technical Advisory Committee. They improved it and came up with what is called a working draft. And that working draft was returned to the Technical Advisory Committee. Once it was received by the Technical Advisory Committee at DOSHS, it was shared by technical staff within the directorate, at that time 73 of them, and each and every officer who had an input shared their input, and that input was captured by the Technical Advisory Committee. That once the Technical Advisory Committee did the reports, they prepared what is called now an improved working draft, and that working draft was resubmitted back to the technical consultant for this particular activity. And once the technical consultant received the improved working draft, he was able to revise it correctly, share with the Directorate of Occupational Safety and Health, and then submitted an initial copy to key stakeholders. And in Kenya, we have a tripartite system whereby we recognize the largest employer representative, which in Kenya is the FKE, the Federation of Kenya Employers. We also have the largest representative of employees representatives, and that is the Central Organization of Trade Unions Kenya. And of course, we also had other relevant agencies, ministries, and departments within government, and also other stakeholders that might be interested in occupational safety and health in oil and gas sector, particularly oil and gas companies in the country, both at the upstream level, the midstream, and also at the downstream sector. Now, so what was waited for was that we were waiting for FKE, COTU, and all the other stakeholders to share their comments. And once they shared their comments, all the comments were supposed to be in written form. And there was a form that was developed specifically to collect the comments from the stakeholders on each and every provision of the draft. Now, once they were completed, these forms were returned to the technical consultants hired by the Ministry of Petroleum, and he included these reports or these comments into a document, and what is called an improved working document. And this improved working document was shared again with stakeholders in a workshop, and we came up with what's called an approved draft. Once we had the approved draft, the same was recirculated to stakeholders, that is FKE, COTU, and all the other people who had participated in making comments. And the real reason for that workshop was actually to ensure that each and every comment had been adequately captured in the draft. The next step was to submit the document to the Cabinet Secretary, Ministry of Labor and Social Protection then. And the main task of the minister at that point was to publish the rule or together with other rules for public participation and invite comments. And that process was completed, and the members of the public gave thousands and thousands of comments, which had to be incorporated into the working document. So all those comments were put together and by the Technical Advisory Committee and submitted to Cabinet Secretary. If you look at this slide, you find that this is the only part that is red, that the TAC included comments and submit to CS. That means that this regulation is actually at. Once it is done with the Cabinet Secretary, of course, he will submit it to Parliament. And when it goes to Parliament, and that's the National Assembly, to be specific, it will go straight to the Committee on Delegated Legislation Rules. Yes, this is the second last slide, I think. You can hear me?
Yes. Go ahead.
We can go to the next slide, please.
Yes,
yes. We need to go to the next slide.
There you go.
We can go to the next slide. Okay, so no. Backwards, please.
Oh, sorry.
Yeah, so I've said that at the moment the rules have been published for public participation, and the comments have been received, thousands of them, and thereafter we'll go to the next step of taking these rules to the Cabinet Secretary to forward to Parliament for final approval. Yeah, so in conclusion, I want to stress that in this country right now, the process of lawmaking must include public participation. If there is any law that is made, be it a regulation, be it an act of Parliament, be it anything that does not include public participation, which is captured under Article 118 of the Kenya Constitution 2020, then that law may be declared null and void by the judiciary or by the courts. So the citizen involvement in policy making, including lawmaking and implementation, is known to strengthen and deepen good governance, promotes transparency, and fosters accountability. So that when the regulations are made, then nobody would say that they are not aware of these regulations because they were adequately consulted at various points of the lawmaking process. So this is my final word, and I want to thank you for listening.
If there are any questions to Dr. Muruka on his presentation, please, you can write in the chat or raise your hand and we give you the word. It doesn't seem so.
Yeah, so thank you very much.
Oh, thank you. Yeah, there's a question. What is the position on DOSH on the WBS sections that were declared unconstitutional?
Thank you so much for the question. I think as we speak right now, there is only one, and it's not even a full section. It's only part of a section that requires the minister to approve the insurance companies that companies have to take for their workers. I was saying it is only as that section purports to require that all employers must take insurance from approved insurance companies from those in the list of the Cabinet Secretary for Labor. So what the court said was that so long as the insurance company is registered, then any person can take any insurance from any registered company as regulated by the Insurance Regulatory Authority. So the most important list is the list developed by the Insurance Regulatory Authority. Thank you.
Simon Kubasu, you can unmute yourself.
Simon has a question.
Oh yes, thank you. Thank you, Dr. for the good presentation. Now, yes, my concerns are about the examples of the regulations that you indicated are under review. And one of the things that you mentioned is that it has taken quite a while, for example, the oil and gas regulations to be, the process. So maybe what are some of the issues that you will highlight that will make it difficult for review of or publication of those rules, And then secondly, you can see you also mentioned about the first aid regulations 2020, and I think in my thinking there are many other regulations or rules that will need review. So what informs the decision to look at some of the already existing regulations that might need review? Thank you.
Thank you very much, Simon. One of the main things that informed review is that we had a new constitution all the way from 2010. And we had to ensure that all the rules and regulations that we are enforcing are aligned to the Kenya Constitution of 2010. So that was the most important. Now, the other thing was that the age of the rules that were obtaining at that particular time. We have the machinery rules of 1959. We have the first rules of 19 construction rules of 1984. So if you look at the age of these rules, of course, after some time, it is appropriate and legal that every rule should be reviewed every 10 years. So we were actually behind schedule with the review of these particular rules. Then the third thing was there are obsolete equipment and technology. In the first aid rules, we had the tourniquet as a requirement. Of course, it is no longer mandatory to have a tourniquet in the first aid room or within the first aid equipment. So obsolete equipment, obsolete technology also informed us to have these rules revised. If you looked at the causes of fall from working in a construction site, especially working from height, we realized that the issue of fall from height had to be re-engineered to include the new trends and the new technology that we have to protect people from falling from height. So these are the three main issues I would say. Of course, we also had some stakeholder requests. Stakeholders were asking us, why do we still have this rule? Why can't we have this in this particular pattern? You know, so those are the kind of things. And the fact that we have moved from factory to workplaces is also a significant shift, requiring the need for relooking at the specific rules that were made in the 1950s, 60s, 70s, and 90s. So Simon, that is what informed the making of the rules. I cannot remember your first question. Maybe.
So sorry, the first question was about. I thought you'll mention about one of the main challenges that makes publication of makes the drafting, not actually the actualization of laws difficult. Okay, my thinking was that maybe public participation to some extent has contributed to some delay, but I think it is important. So is there any other factor?
No, public participation has not been the biggest issue. The biggest issue is stakeholder engagement. What we noted during the publishing of the working on occupational safety and health, oil and gas regulations, was that key stakeholders kept on shifting their goalposts. So once you get a full draft today, you realize that after they have read it afresh, they change their goalpost. And sometimes the other issue that brings this serious problem is that the representatives from these organizations, the key stakeholders, do not go back to share with their institutions, what they had agreed or what had generally been unanimously accepted as key provisions. So when they go back and they share these documents, they are rejected by those organizations, and then they have to come back with a new goalpost. So that has been a big problem, and we hope that in future we are able to get high level or the highest level representation as we have had before during other stakeholder engagements. Thank you.
Thank you, Dr. Muruka. I'm sure we'll get some more questions which are to you. If you don't mind, we'll email them to you, and then we can get the answers and share them. Will that be okay? I suppose so. We've done this before. So if there are any eventual questions to Dr. Muruka, please write them in the chat, and we'll collect them and send them to Dr. Muruka, and then we'll get our answers. We'll share with you as we've done earlier.